tanya kejap. Kau mesti tanya kejap apa?
On October 9, 2017, Ada Tursinawati, an Indonesian cleaner, arrived at a homestay in Ipoh to work. She was attacked with a parang and died at the scene. The suspect, Khairul Azizi, later surrendered and admitted the killing, saying voices drove him to act. He had a history of meth use. He had passed psychiatric treatment. At trial, experts disagreed. One said schizophrenia. Another said he was of sound mind. Courts found the killing premeditated and rejected the insanity defense.
Okay, now moving on to the judgment of the case. So what will happen to Khairul Azizi? So in this case, the Court of Appeal reaffirmed that medical insanity is different from legal insanity, and the court accepted the evidence of the prosecution psychiatrist, which is Dr. Ian, who is a forensic psychiatrist, who found that at the time of the offence, Khairul Azizi had no schizophrenia, no psychotic episode at the time of the offence, and the accused was only dependent on drug, which is methamphetamine, and not legally insane. Other than that, the accused behaviour, which is by opening the gate, attacking deliberately to the victim, riding to the police station by himself and explaining to the police what happened, showed that he knew what he was doing and his act was wrong. So the court decided that the appeal was dismissed and the defence of insanity under Section 84 of the Penal Code failed, and the conviction for murder under Section 302 of the Penal Code was upheld, and the death sentence was commuted to 35 years of imprisonment and 12 strokes of cane due to the abolition of the mandatory death penalty.
For Irina, each day was a battle against a storm of voices only she could hear. A battle that would end in tragedy. Her schizophrenia, a silent progressive illness, was pulling her away from the family she loved. On October 18, 2018, her mind shattered. In a state of unsound mind, she harmed her children, forever changing their lives. Forensic psychiatrists would later confirm the devastating truth. Irina was in the grip of a severe mental disorder, legally insane.
Okay, now for the judgment for the case of public prosecutor against the Irina Binti Jimmy. So the court accepted the evidence of the forensic psychiatrist that the accused suffered from severe schizophrenia. She experienced commanding auditory hallucination and delusions, and her cognitive faculties were severely impaired. Although the accused was aware her physical action, the court accepted expert evidence that awareness does not equal understanding, and she was unable to appreciate that her act was wrong or unlawful. And the prosecutor ultimately considered that the accused was legally insane at the time of the offence. So the court decided that the accused was acquitted for murder by reason of insanity, and the court ordered that she be detained at the hospital Mesra Bukit Padang during the pleasure of the ruler of the state of Sabah, pursuant to Section 7 and 348 of the CPC.
Welcome to Talk the Law, Know the Code. As usual with us, KHAIRUNNISA and
I'm Emillyn Natasha.
So, in today's episode, we will be exploring a tricky but fascinating topic, which is the insanity defense. We'll be talking about criminal responsibility and mental illness, how the law approaches the insanity defense in Malaysia and from the perspective of the UK, as well as how Islamic law views criminal liability for the mentally ill persons.
Alright, so to set the foundation, can you explain to all of the audience how does Malaysian law and English law deal with the insanity defense?
Of course, I will explain the insanity defense under the Malaysian criminal law first, followed by the position in the United Kingdom, and then I will compare both approaches to highlight their similarities and differences. So as we all know, in Malaysia, a person can be convicted based on the presence of two essential elements, which is first, actus reus, referring to the prohibited act, and second, mens rea, referring to the guilty mind. An accused person who suffers from mental illness may lack the mental capacity or the mens rea, and this situation is recognized under Section 84 of the Penal Code, which provides for the insanity defense. So Section 84 states that an act is not an offence if, at the time of committing it, the accused was of unsound mind and incapable of knowing the nature of the act, or that the act was wrong or contrary to the law. And the concept of unsoundness of mind is not exhaustively defined in the Penal Code. So, as a result, Malaysian courts rely heavily on psychiatric evidence to determine whether the accused's mental condition satisfies the legal threshold or not. So, in regards to the procedural safeguard in Malaysia, when the court has reason to doubt the mental condition of the accused, it may order a psychiatric examination under Section 342 of the Criminal Procedure Code. So, did you know about the recent news of the accident involving the Honda driver just in Terengganu, if I'm not mistaken?
Oh, the UNISA student, right?
Yes. Did you know that magistrate court in that case has ordered that driver to undergo a psychiatric test in Johor Bahru Hospital?
Really?
Yeah, so that shows that Section 342 of the Criminal Procedure Code is actually applicable in Malaysia, and that the insanity defense could be used for that case. So, for the burden of proof, Malaysian law follows McNaughton rules, which every person is presumed to be sane. And the burden of proving insanity lies on the accused and must be established on a balance of probabilities. The defense must prove that at the time of the offence, the accused was suffering from a defect of reason due to mental illness, such that they were incapable of understanding the nature or wrongfulness of the act. So, a leading Malaysian case illustrating this principle is Juso against public prosecutor. Did you remember this case when we learned criminal law with Dr. Mas?
Oh, I think I've heard of it. Juso, right?
Yeah. So in this case, the accused killed 4 individuals while suffering from acute mania. And although he was aware of his actions, medical evidence showed that he lacked the capacity to control his conduct. So the court in this case accepted the psychiatric testimony and acquitted the accused on the ground of insanity, and confirming the temporary mental impairment may fall within Section 84 of the Penal Code. So now let's go and fly to United Kingdom. The insanity defense is governed by the McNaughton rules as well, which originated from the case of R against McNaughton in 1843. So, under the UK approach, the defense must prove that the accused was suffering from a defect of reason caused by a disease of the mind at the time of the offence. And the accused must show that they either did not know the nature of and quality of the act, or did not know that the act was wrong. And the UK test is commonly referred to as the right-wrong test and places strong emphasis on cognitive awareness rather than emotional disturbance. So, as we can see, unlike Malaysia, the UK applies the test more narrowly. Emotional instability, loss of self-control, or temporary distress will not qualify unless they directly impair and affect cognitive understanding. So, as a result, the UK approach has been criticised for being outdated and overly restrictive, particularly in light of modern psychiatric understanding. So, to compare Malaysia and the United Kingdom, there are several important similarities and differences that we can see. Both jurisdictions adopt the Macnaghten principle and place the burden of proof on the defence, i.e. the accused. However, Malaysian court appear more flexible in interpreting the unsoundness of mind, allowing temporary mental impairment such as acute mania in the case of Juso to fall within the scope of Section 84. And in contra, the UK applies a stricter cognitive standard, focusing solely on the accused's ability to distinguish right from wrong at the time of the offence. So, procedurally, Malaysia also provides detailed mechanism for psychiatric observation and detention under the Criminal Procedure Code, like Section 342 of the CPC, whereas the UK approach relies more heavily on post-trial disposal orders. So that means we can say that UK relies more on the judge itself.
Oh, so you can say that UK is more strict than Malaysia.
Yeah, of course, because they are very outdated, I would say. So, to conclude, while both Malaysia and the United Kingdom recognise insanity as a complete defence, they differ in the breadth of its application. Malaysia adopts a more pragmatic and medically responsive approach, whereas the UK maintains a narrower and traditional framework. So that's how the insanity defence works under Malaysian and UK criminal law. But law doesn't look at mental illness in just one way. To see a different perspective, I will now pass it to you to explain how Islamic law approaches criminal responsibility for the mentally ill person.
Alright, so when we talk about criminal responsibility, we often ask whether someone committed the act, but Islamic law asks a more fundamental question on was the person even legally responsible in the first place. So in Islamic law, criminal responsibility is basically based on the concept of taklif. So have you ever heard of the term taklif?
No, I haven't.
Alright, so taklif refers to a person's legal and moral accountability before God and the law. So for taklif to exist, two key elements must be present. First, akal, which means sound intellect, and second, free will. So for this means mukallaf. Have you heard the?
Yeah. I heard Ustaz Arabic always say the word mukallaf.
Yeah, exactly. So, if a person's intellect is absent or severely impaired, Islamic law does not recognize criminal responsibility. So, without sound mental capacity, punishment cannot be justified.
Oh, so basically if someone cannot think properly or control their actions, they are not held liable.
Exactly.
Oh, yeah. I remember Ustaz Arabic like in Islamic criminal law.
Right.
Okay.
Alright, next, a person who suffers from serious mental illness is known in Islamic jurisprudence as majnun.
Oh, I know that.
Exactly. So, classical Islamic scholars unanimously agree that a majnun cannot be held criminally liable because such a person is unable to distinguish between right and wrong or control their actions meaningfully.
So it's not sympathy, it's justice.
Yes, Islamic law doesn't punish where there is no understanding. Sebab it's unfair lah kan. So this principle is clearly supported by a well-known hadith of the Prophet Muhammad SAW, peace be upon him. The penalty is lifted from 3 persons.
Oh,
Okay, first, the sleeping person until he awakens. Second, the child until he reaches puberty. And lastly, the third one, the insane person until he regains sanity. So this hadith clearly established that criminal liability does not attach to an insane person regardless of the seriousness of the act committed.
So this is a very clear religious basis for why insanity removes liability.
Exactly. However, Islamic law does not ignore public safety, of course. Where punishment is removed, Islamic jurisprudence emphasizes protection, medical treatment, and supervision of the mentally ill individual or the majnun. So, any form of confinement is aimed at care and prevention of harm, not retribution.
Oh, so the focus shifts from punishment to care and community safety. Am I right?
Yes, responsibility may also shift to guardians or the state to ensure treatment and that society is protected.
Oh, I see.
So, when we compare this with Malaysian criminal law, an important contrast emerged. Right. So, as you explained, Section 84, although Section 84 of the Penal Code provides an insanity defence, its application is narrow and highly dependent on strict medical evidence and judicial discretion, right? So,
So even if someone is acquitted, Malaysia does not have a full treatment focused framework like Islamic law does.
yes, the system may appear more punitive than rehabilitative. So, Islamic law reminds us that justice is not only about punishment, but about understanding the human condition.
So that actually raises a really important question tau.
Yeah. Is Malaysian law adequately equipped to deal with mentally disordered offenders in a way that is both just and human?
Definitely something we're thinking about lah.
Yup.
Okay, so that's all from us. Thank you so much for listening to our podcast and stay tuned for the next topic.
Yes, see you in the next episode. Bye-bye.
Moving on to the next part, which is on the legal analysis relating to Section 84 of the Penal Code and suggestions on improvement for reform to Malaysia's legal system. So for this part, it is divided into two sections, which is the strengthness of this provision and also the weakness of this provision, which is Section 84 of the Penal Code. So for the part of strengthness, we can see that Section 84 is more broader compared to Magnetic rules, which it emphasizes more on unsoundness of mind instead of disease of mind, resulting in more offenders can be punished for their action even though they are suffering from mental illness. So for the second one, Section 84 of the Penal Code focus more on the time of the commission and not the whole condition of the patient or the accused. So it is important to know that the accused does not have control over his act during the time of commission due to mental illness of the accused. So the next one is the weakness of the provision itself. By the first one, the provision does not specify what type of mental illness that can be suffered by the accused during the time of commission, such as schizophrenia, bipolar, depression, or etc. The second one is it is hard to pinpoint whether the accused really suffered mental illness at the time of the commission and really need a medical evidence to prove, and only based on circumstantial evidence, since most of the accused only diagnosed after the crime committed, and it might result in floodgate of litigation where many offenders tried to raise this defense. So for the next part is the suggestions for improvement for Section 84 of the Penal Code for reform for Malaysia's legal system. So we have provided 5 ways to improve Section 84 of the Penal Code to counterclaim the weaknesses of the provision itself. So the first one, the provision can include types of mental illness in the provision such as schizophrenia, depression, bipolar, or any other that might affect the mind's ability to function well. The second one, the provision can provide illustrations on what is the example of wrong or contrary to law. The third one, the provision can provide illustration on the condition where the accused does not know what he is doing at the time. For example, he is cutting people's neck, but he thought that he is cutting a bread. The next one, the provision can make it obligatory for the court to request for medical evidence report on the offender behavior before the commission to ensure he really suffers from mental illness and not just using it as an excuse to escape punishment. As for the last suggestions, upon acquittal, the accused must go to mental hospital for certain fixed period or until he really recovers, and with probation or observation period even after the release to ensure that no re-offence happened, or else he shall be sent back to the mental hospital for treatment.